everyone, and thank you for joining us for today's event, Bail Reform at a Crossroads, Impacts on Public Safety and Justice. My name is Khalil Cumberbatch, and alongside my colleague Mark Levin, we co-lead the Centering Justice Initiative here at the Council on Criminal Justice. And as always, we're honored to have you and our speakers with us today to talk about today's topic. Before we begin, just a quick housekeeping note. We will have Q&A toward the end of the hour. And so please feel free to drop your questions into the chat throughout the discussion. We will try to get to as many of them as we can before we end today. And also a recording and a summary of today's events will be made available on our website afterward, as well as our social media. So please drop your questions. We want to try to get to as many of them as possible, and please do that throughout today's conversation. Mark, I turn it over to you.
Well, thank you, Khalil. We're really pleased to have such a timely discussion here today on the topic of bail reform. And bail is a very challenging issue and one that really distinguishes the United States in many ways. We're the only country besides the Philippines that has commercial bail, but it should be said there's other countries that have higher pretrial detention rates than the United States, which illustrates there's obviously many different issues under the headline of bail reform, which can determine who stays in jail and who gets out prior to their trial, and secondly, what conditions, including money, may be involved. The first kind of major bail reform in the U.S. was back in 1966 with the Federal Bail Reform Act. And then in the 90s, Washington, D.C. eliminated money bail for all practical purposes. And still a few people get financial conditions when they're released, but nobody's held in D.C. Because they can't pay money. But they might be denied bail, and we'll get to all of that. In the 2010s, we saw an expansion of various bail reforms around the country, some of which sought to either eliminate or reduce the use of cash bail. The main issue throughout these decades has been the question of equal protection, the idea that if somebody who's less dangerous ends up staying in jail because they don't have money versus someone who's more dangerous getting out of jail because they do. There's also, though, a concern that, again, there's people who are released who should be in jail. We've seen high-profile incidents where serious crimes have been committed by people on pretrial release, whether they paid money or not. And one place where this has been most controversial has been in New York City. The state of New York adopted major bail reform almost a decade ago now, and there were some changes to that subsequently. But for example, outgoing mayor of New York, Eric Adams, has argued that that contributed to an increase in crime, the post-pandemic crime, which of course has since gone down in the last couple of years. But there was, for example, more people, some 211 individuals arrested 3 times for burglary in June of 2022, compared to 87 in the same period in 2017. Of course, other things were going on besides bail reform, and that's one of the complications. It's very difficult to untangle what the impact of bail is versus other developments in society, like pandemics, as well as other criminal justice policies. Changes. The Brennan Center released a study in 2024 of 33 cities who had either passed bail reform or not, and basically found no statistical relationship between bail reform and crime rates. One of the things that we can say, I think, in looking at the literature is it's really important to make distinctions based on objective factors like risk of committing a new crime, risk of absconding, and that we know that when you keep low-risk people in jail pre-trial, you can actually increase rearrest rates as people's lives are destabilized through losing employment and housing. But we also know there's people that are on crime sprees, whether it's a serial killer or someone who's committing domestic violence repeatedly, that does need to be, at least in my view, there's a small slice of people who need to be in jail prior to trial, regardless of how much money they have because of the danger they pose. So that kind of creates the Rubik's Cube here, where we're trying to turn the dial exactly right and make sure we're detaining the people that need to be detained, but not making things worse for other people and taxpayers by using pretrial detention excessively. So I'll kick it back to Khalil to kick off our discussion with that background.
Yeah, no, thank you, Mark. Just a couple of points. So Mark mentioned a lot of reports and statistics, and despite these findings, bail reform has continually found itself back in the national spotlight, in particular when President Trump signed an executive order to Director AG Pam Bondi to review federal fundings of jurisdictions who do not roll back their bail policy reforms, and citing these policies as major contributions to the spikes in quote unquote crime. And so we have a lot to get into today, and we are happy to have Don Simon to kick us off from Loyola University in Chicago to offer some additional points to ground the conversation in data. As we all know, CCJ always seeks to call balls and strikes based on the data available. And so we're really excited to have Don join us here to ground the conversation. Don is also a professor in the Department of Criminology, and Don's work focuses on prosecutorial decision-making, prosecutorial performance measurement, and of course, bail reform. So Don, I'll turn it over to you for your presentation.
Great. Thank you, Khalil. Thank you, Mark. Thank you, everyone, for having me here. My name is Don Steeman. I'm a professor at Loyola University Chicago. I'm also one of the co-directors of the Center for Criminal Justice at Loyola. And with my colleagues in the center, we've been evaluating the implementation and impact of Illinois' bail reforms over the last 4 years. I just want to ground the conversation in data, I think, or the relevant research on the impact of bail reforms. I think it's important to first consider the many ways that we can conceptualize bail reform, because before we can start to think about the impact of reforms on crime rates or the impact of reforms on new criminal activity of those released pretrial or even on failure to appear rates, it's important to think about the many different ways that bail reform is implemented, or the ways it's conceptualized. So I think we can think about bail reform in a couple of ways about what reforms do. So there are some reforms that are focused specifically on the use of detention, and regardless of how they may impact the use of monetary bail or restrict the use of monetary bail, some reforms are just there to place restrictions on who or when someone can be detained pre-trial. So there are limitations on who can be detained pre-trial through, or for example, limiting it to a specific subset of offenses. So for example, in Illinois, it's limited to forcible felonies, non-probational felonies, weapons offenses, and domestic violence. And those are the only individuals who can be detained for public safety considerations. New York State does something similar with bail eligible offenses, which are primarily violent offenses, with some exceptions. But in this instance, both states are trying to limit who can be detained pre-trial by setting out a specific subset of detainable offenses. There are other instances in trying to limit detention by placing limitations on judicial discretion to detain. So whether that requires a prosecutor to file a petition to detain before a judge can detain, or absent such a motion actually prohibits the imposition of detention. And then there are other instances where reforms are focused on the reasons for detention, so limiting why someone can be detained pre-trial. So it may require the individual to be a high risk of flight or public safety based on a pre-trial risk assessment tool, or it may be based on things like a showing of willful flight, for example, in Illinois, that it's not enough to show that someone might abscond, but it's a requirement that it shows that it would be a willful absconsion. And then there are other instances where there's a presumption of release. And it's a presumption that has to be overcome either by a prosecutor or by rationale provided by judges. So in all of these, they're trying to limit the detention in some way. And these are often combined with reforms that are specifically focused on the use of monetary bail and place limitations on who or when someone can receive monetary bail. So there are places like Illinois and New Jersey that have effectively eliminated the use of monetary bail in all cases. So they're by taking monetary bail out of the equation and combining that often with who can be detained, or limitations on who can be detained, right? We can limit detention and the use of wealth, for example, to determine who can be released. But there are other places who have limited that to, say, just misdemeanor offenses or traffic offenses. So in Colorado, several jurisdictions have prohibited the use of monetary bail for low-level misdemeanors or traffic offenses. The same is true in reforms that took place in Harris County, Texas. And then there are other limitations on the use of monetary bail. So limitations on which offenses can have monetary bail imposed, or or requirements that monetary bail be set at something that is affordable or that a defendant is able to pay. So California requires judges to consider ability to pay, for example. Wisconsin requires judges to set bail amounts at a level only to ensure that a defendant returns to court and not something higher than that. So I think it's important for us to first kind of conceptualize bail reform in that way, but it's also important to think about the goals that we're trying to achieve in bail reform. And some of them are just to reduce the number of people held in pretrial detention. Other reforms are there to ensure that, quote unquote, the right people are detained so that we limit detention only to serious cases and prevent non-serious cases from finding their way into jail. Or others are to reduce the degree to which wealth determines pretrial release. But many of these reforms are also there to make sure that the process is fairer, that it's more deliberative, that it's more transparent. So things that require petitions to detain or require defendants to be represented by counsel or requiring judges to articulate the rationale for either detention or the imposition of monetary bail. All of those are goals that I think it's important for us to consider while we also consider the unintended consequences of reform. And a lot of the discussion has been more focused on the unintended consequences around the impact on crime rates or new criminal activity of those released. And I think just one more thing that we have to think about when we ground this is these reforms are implemented at different scales and by different entities. Many of the reforms that we talk about are implemented in single jurisdictions, often by prosecutorial policy or by court order. Statewide bail reforms are very different, right? That impact that impact an entire state, and all jurisdictions at the same time are very different. So we're talking about, to provide a simple answer about the impact of bail reform is quite difficult, right? We're talking about reforms that are addressing different aspects of pretrial release and decision-making, that are relying on different levers to achieve those results and that are implemented at different scales. What's interesting is despite these differences in the content of reforms, the research paints a pretty consistent picture. Bail reforms are not associated with increases in failures to appear for the most part. They're not associated with increases in new criminal activity while individuals are on pretrial release, and they're not associated with increases in crime. So as Mark already pointed out, the best example of that is probably the Brennan Center's look across 33 jurisdictions about the impact of bail reforms on overall crime rates. And the Brennan Center found no relationship between reforms and changes in crime rates. Other studies conducted in New York State also showed no relationship between reforms and crime rates. Those conducted in New Jersey found an actual decline in misdemeanor arrests after bail reform and no changes in other arrests. A subsequent study in New Jersey looked at the impact of bail reforms on shootings and homicides and found no impact of bail reform on changes in crime rates. When we look at new criminal activity of individuals who are on pretrial release, the concern is that limiting bail reform or bail and pretrial detention may actually increase recidivism by removing the short-term incapacitation effect of jails or the deterrent effect. At the same time, as Mark pointed out, there's a concern that we might actually get lower recidivism rates by increasing release because we're avoiding the harmful impacts of detention, which can disrupt jobs and housing and family connections. Again, the research is pretty consistent, showing that reforms are not associated with increases in new criminal activity while on pretrial release. Research conducted by the Data Collaborative for Justice in New York found that reforms actually led to lower recidivism rates after they were passed in New York State. In New York City and the rest of the state, there was no impact on recidivism rates. Analysis done in Harris County, Texas, also found that after an end to cash bail for misdemeanor cases there was no change in year-over-year arrest rates. Analyses done in Philadelphia after the District Attorney Krasner's change in bail policies found no evidence that financial collateral had any deterrent effect on pretrial crime of those who were released. So we see this kind of picture being painted across all of these jurisdictions and across the relevant research. Even when comparing very different types of bail reforms, we see very consistent outcomes. Really no impact of reforms on new criminal activity of those released and no impact on long-term crime rates in any of those jurisdictions. And with that, I'll turn it back over to Mark and Khalil to open the conversation.
Well, thanks so much, Don. As you stated, the data shows us one thing, particularly in certain parts of the country, and sometimes the perception of these reforms don't always align with what we're seeing is actually happening based on the data. And so, thank you, Don, for your presentation. It's always great to have our conversation grounded in data. I want to briefly introduce our panelists. Won't read bios. Links to each speaker will be included in this presentation. So first, we have Erin George from the Bail Project, who is the National Director of Policy. We're also joined by Prosecutor Reynolds, who is prosecutor in Atlantic County out of New Jersey, one of the states that you referenced, Don, in your presentation around their efforts on bail reform. And of course, we have Spurgeon Kennedy, past president of the National Association of Pretrial Service and Pretrial Service Agencies. We generally start our panel discussion with what we call a quick fire round. And so I'm going to ask a question, same question posed to each of you. And if you can make your answer as short as possible, because we really want to get through some of the other questions that we had, particularly the ones that I see coming into the chat. So we'll start with Prosecutor Reynolds, and then Erin, and then Spurgeon. So the question is, as we are all here to learn today, would you consider past bail reforms to be a success or a failure, and why? And I know that I said, please keep your answers short. And of course, I asked you a very heavy question like that. But any level of brevity that you can offer us would be greatly appreciated. So, Prosecutor Reynolds, can we start with you? Would you consider the bail reforms in your state, let's start there, to be a success or a failure, and why?
First of all, thank you. Appreciate the opportunity. And in the sake of brevity, I'm going to say yes, it's an absolute success based on data. And I'm going to give you some real brief statistics that will bear out and prove exactly that. Start with Atlantic County, post-bail reform. Our detention rate for Atlantic County is first in the state, but our summons rate is the highest, meaning that we put the most people on summonses. 66% of the time we release them, and we're only detaining the most violent offenders. If you look at the stats for both homicides and shootings, I'm going to give you the numbers. It's shocking. 2012 in Atlantic County, we had 30 homicides. 2017, when bail reform was instituted, we had 22 homicides. In 2023, my first year as prosecutor, 12 homicides. In 2025, 4 homicides, only 2 are shootings. One is a domestic, one was actually a justified homicide on a home invasion. So instituting bail reform, detaining the most violent criminals, the homicides way down. Shooting statistics for the entire state of New Jersey. In 2021, there was 1,091 shooting hits. In 2025, only 448 shooting hits. The most violent criminals are being detained. Violent crime is coming way down. And if you really hone in on the decision-making of summons versus warrant, you can detain the people that need to be detained and allow the rest of people to move on with their life, just as was just discussed. Thank you.
Thank you, Prosecutor Reynolds. Erin, over to you. Would you consider past bail reforms? I know that you did a ton of work in the bail reforms in New York, but obviously work at the Bail Project and see the impact of bail reforms all across the country. Have they been a success or a failure, and why?
Yeah, I think on the whole, I would absolutely consider past bail reforms to be a success. But I think, as Don was saying, bail reform is not all created equal, not all created the same. But I do think that at the core, bail reform fixes a fundamental flaw in the pretrial system, right? It makes sure that decisions about who's released, who is detained before trial are made based on evidence of an actual risk of flight or an actual threat to public safety, and not about how much money someone has in their bank account. When you have a cash bail system, who stays in jail and who goes home before they're convicted is about wealth. And that's not a system that's focused on safety or focused on fairness, and bail reform corrects for that. Which again is not to say that all bail reform is created equal, right? Doesn't mean that there are not unintended consequences that we have to take very seriously and that we have to look out for, things like expanded preventative detention, expanded electronic monitoring, and I think the most successful bail reforms also reduce pretrial jailing, and they go beyond just eliminating or restricting cash bail. So they do things like provide court reminders, transportation support. They invest in community-based services that help people succeed while they're awaiting trial. You see that in places like DC, Illinois, New York. These are also interventions that we use at the Bail Project every day. We've helped support nearly 35,000 people safely return to 93% of their court dates. And again, I think what's so great about where we're at right now in the bail reform movement is that we have actual evidence that bail reform can both reduce unnecessary pretrial jailing and have no negative impact on public safety, like Don just laid out.
Thank you, Erin. And of course, you guys positioning and engaging with a number of groups on the ground, as well as elected and appointed officials on this issue, obviously gives us a really good vantage point. Spurgeon, same question to you. Would you consider past bail reforms to be a success or a failure, and why?
Yeah. Well, I would say ditto to everything that's been said so far, but that might be a little too brief. I think when you talk about success, you have to define what you're talking about, and I think we've done that to a point. When you're looking at successful bail reform, the questions are the most appropriate people being released? Are we seeing reductions in missed court appearances? Are we seeing at least no increase when it comes to rearrests, especially at the pretrial stage? Are we not seeing increases in people being rearrested for violent offenses or being arrested quickly after release? And in all of the bail reforms that I've seen, at least the research that I've seen, as Don mentioned, the answer to that seems to be, yeah, these things are happening. We are being successful. We may not be releasing a greater percentage of people, but we're releasing the right kind of people. We may be detaining people pre-trial, but at least we're detaining them based on due process hearings and procedure, and not just here's $50,000, good luck, and trying to make it work for you. So I think that, yes, they have been successful. I think the most successful of these reforms that have been at the state level, like Illinois, like New Jersey, New Mexico, like Washington, D.C. years ago. And I think these really successful bail reforms have opened the door for other reforms. For example, do we need public defenders or defense advocates at the beginning of the process? Should prosecutors look at cases a lot sooner in the process that they're doing right now? Should there be multiple bail reviews for people that are detained? I think once you start one reform, it's easier to sit down and figure out whether other reforms are needed. And I think in those states, especially, that's been going on.
Yeah, no, you raised a good point, Spurgeon, and I hope that we can touch on this, or maybe either of you can touch on it in some of your comments. But you're right, the bail reform issue has, to some extent, been a wedge to open up the door to have other conversations around other tweaks and reforms that can be done to the criminal justice system. In some cases, to the pretrial part of it, but also in other parts of the criminal justice system. Second question of our quick fire round, and again, we can start with Erin and then work our way. I'm sorry, we can start with Prosecutor Reynolds and then work to Erin and then Spurgeon. What are some of the misconceptions that the general public, the average Joe and Jane, so to speak, has when they hear or when they think of something like bail reform?
So great question. And is that, quite frankly, it was the first question that I was asked at the governor's office when I was being interviewed for this job. And it really depends on the individual person in the general public and how they're actually looking at it, and what news information or what news channel or how they're getting their information creates that perception. And I'll give you the example that I used that I think is crystal clear. For the person who gets released on bail reform and remains law-abiding and goes to work and provides for their family and becomes a contributing member of society, everybody that sees that example thinks bail reform is absolutely wonderful and it's the right thing. Where it goes off the tracks is if there's a victim of a crime where someone was released, that person who's a victim and all of their family members believe that bail reform is the worst thing ever, because if that person was detained, that crime would have never happened. So how those things get reported and how those things are, that communication and that information is being shared, then affects the perception of the recipient of the information. And then depending on how they're getting their information and who they're sharing it with, then creates those misperceptions. What my job has been in Atlantic County since I've been here is to take those misperceptions and the people not understanding what's going on and just give them facts as often as I possibly can. And we issue press release after press release with only the facts. And I think that's how you solve the problem. But it really, it's a challenge. It's a challenge.
Yeah.
Thank you.
Now, I can imagine the challenges that that prosecutors face when dealing with someone who has been charged with committing a crime and someone who has been the recipient of harm because of that charge. So, Aaron, same question to you. What are some of the misconceptions that the general public has surrounding bail reform?
Yeah, this is sort of a similar answer, but a different angle to what DA Reynolds was saying. I think a big misconception is the general public, but also lawmakers that we're speaking to often in states across the country, is that bail reform equals no accountability, that it means is some sort of like get out of jail free card. And that's simply not the case, right? We're not saying no bail means, charges are dropped, you don't have to show up in court, you don't have to see your case through. We're just changing the metric for deciding who deserves freedom. And we're using evidence of actual risk instead of using money. People do still face their charges when they're released. They do still have to show up in court. They do still have to see their case through. And rather than using money as the decision-making metric, we're talking about a judge that has to actually put evidence on the record that someone poses a risk of flight or poses a risk of a threat to public safety. And I think when you lay it out that way, it starts to make sense to people. We're not talking about a huge overhaul of the system in some ways. And I think, as Mark laid out at the beginning, having a private bail bond industry sort of corrupts the conversation to some degree. But we're really just talking about taking money out of the equation and having a conversation about evidence. We're not talking about a big radical change. We're just asking the system to do what it's supposed to, right? We're asking it to uphold the presumption of innocence and only incarcerate when you haven't been convicted if there's some evidence that you did what you've been accused of.
Thank you, Aaron. And again, you guys' position at the Bail Project across the country gives us a really good perspective on what you're seeing on the ground and what you're hearing from the constituents that you work with. Over to you, Spurgeon, same question. What are some of the misconceptions that the average Joe and Jane has about bail reform?
Yeah, I come from a city, Washington, D.C., which over the last 5 years has seen about 90% of the people released make all scheduled court dates, about the same percentage not commit new crimes pre-trial, maybe less than 1% charged with a violent offense while they're out. And if you ask the typical Washingtonian about bail, they will tell you about the last time they saw a news story about somebody released on bail who committed a crime, and isn't that bad, and shouldn't these people not be able to get released? Again, most people are not familiar with the justice system because most of the sources of news that they get, don't tell them about the justice system. We're not very good at putting our message out. We certainly aren't as good about our message as our distractors are about theirs. So going with Aaron's point, accountability is always a big thing. You're telling me that people are being released who committed crimes. You have to let people know that bail isn't a privilege in this country, it's a right. And it's not the people who get released that you have to worry about or be concerned about, it's the people being detained. And if you're not careful in how you detain those persons who should be released, that becomes the problem. But again, it's just, I don't think we've been good at getting that message across. Certainly, we have not been as good as the people on the other side about getting their opposite message out there.
Thank you, Spurgeon. Mark, I'm going to turn it over to you now.
Sure. Well, I wanted to kind of probe the where the rubber meets the road, number one, and number two, where there's kind of potential areas of disagreement, even though I think everyone on this panel agrees on many things. You know, one of the things with New Jersey, of course, is a lot of resources were put in for millions of dollars for training, technology, pretrial services, and supervision. And there's a real question about whether every state is prepared, has the political will to do that. And I guess the two areas I think of potential disagreement that perhaps each of you can address are, number one, I know Aaron referenced this earlier, but what is the role for restrictive conditions for certain individuals for pretrial, the people kind of on the borderline who might otherwise be detained, whether that's electronic monitoring, or, you know, saying you can't, house arrest obviously is, some people are under house arrest. We obviously don't want to over supervise people, but we also realize if we are going to look at those borderline cases of people that otherwise would be in jail, we have to kind of consider what conditions might be appropriate based on an individualized assessment. And then the second area of potential disagreement that perhaps each of you could address is what should the pretrial detention net? I think we've all established we don't want to do it based on how much money someone has, but should it be for, you know, any violent felony that a court could deny bail, or should it be any felony or any crime? How should we define what situations we're saying judges can deny bail, and presumably also have an appeal from that as well, an expeditious appeal? So I guess Prosecutor Reynolds, do you want to start out with kind of on that one?
Sure. Appreciate the opportunity again. So I'm gonna take you through like a journey of what New Jersey bail reform is, and I'm very fortunate because of my past relationships. I started in municipal court as a municipal prosecutor, and that was a debtor's prison. I saw people who could not afford bail be detained, and people who could afford bail be released. And then I watched bail reform, and just as Mr. Levin said, New Jersey had the palate and the political will to spend all this money. And one of the things they created was an algorithm for a PSA, a public safety assessment. And what they really did well, and this is my opinion, where they train the judges can deviate from the PSA if there's a threat to public safety and they need to build a record. And one of the things that was discussed earlier was prosecutors looking at the case earlier and defense lawyers being involved earlier absolutely allows an examination of the merits and to determine if that person is a public safety risk. That is so much better than the old debtor's prison that we had. And it also gives the judges discretion. Now, one of the things that I can tell you, the challenges where I may be in disagreement with some people, is some of the judges needed to be reminded that public safety is a caveat to the PSA, because some become rubber stamps just for the PSA. And what we've done in our office is, where a judge releases someone who's a violent offender over our objection, where there's a lot of evidence to show that that person's a public safety risk, we tell the public this defendant was released over the state's objection by Judge so-and-so, knowing that everyone's accountable, because if that person goes out and commits a crime, that's everybody's responsibility that that person's on the street. The other part of that equation is, I'm going to tell you, we've seen an incredible measure of success where everybody, even the public defender's bar, is agreeing to detention in certain areas where they know it's a public safety risk. But it's been a learning process, and every county handles it differently.
Persian, did you want to? Oh, go ahead, Aaron.
No, I'm happy to. Sorry, did you want to go somewhere else first? You know, I'm always happy with a wonky question off the cuff.
Yeah, go ahead. I teed up a few things there for you, Aaron.
So I think when in talking about restrictive conditions of release, you know, I really appreciated at the start of this conversation that we talked about how bail reform is just one piece of the puzzle. And what's not discussed frequently is that bail reform usually happens in the context of a lot of other reforms to the pretrial process, whether that be discovery reform, whether that be speedy trial reform, whether that be counseled appearance, et cetera. That's usually embedded in these reforms or a part of the process of these reforms. And I think when we're talking about conditions of release, you want, again, the default to be the least restrictive conditions of release, but you can layer the same due process on to restrictive conditions of release that you do to detention. So you can have, if someone is going to be assigned electronic monitoring, you can add in that if they comply for X amount of time, they are automatically taken off, or there's an automatic rehearing to review that as a condition. So we don't have to have perpetual electronic monitoring be the default. There are ways to make sure that we are constantly moving away from restrictions. I think that we've, again, seen at the Bail Project that voluntary supports and services and providing court notifications and free transportation get people safely back to court the vast majority of the time. That isn't to say that there is not a universe where we should be considering having a range of alternatives, but we should make sure that those aren't the default. In the question about the detention net, I think this may not be the most popular answer among even among advocates. I mean, I think that we want to reserve detention for the most serious cases, but I actually think that the legal standards and the evidentiary standards are what is most important here, requiring clear and convincing evidence of a demonstrated threat to clearly identified individuals or individual for public safety, of risk of willful flight instead of a risk of failure to appear is really important. And I think that's where you actually get to the place of cabining detention in the best way. And, you know, I think the Bail Project, we feel like we always want a judge's judgment to be what makes that decision an individualized decision that's based on evidence. I think we have seen the use of risk assessment tools really change over the last decade. And I think to what DA Reynolds said, it become a factor in a judge's decision making. And I think that's a shift that has really happened. We saw bail reforms a decade ago that were being made solely on a risk assessment tool's output. And oftentimes the inputs to a risk assessment tool are biased. We don't want a risk assessment tool, at least the Bail Project's position, we don't want that to replace those strong evidentiary standards and that due process. That being said, I think that the practice and use of risk assessment tools has really shifted in the last 10 years.
Spurgeon, did you want to address this as well?
Yeah, and this is my pet peeve when it comes to working with my pretrial friends. We use conditions way too much, with electronic monitoring, drug testing, and reporting being the main culprits. There are too many people on too many conditions across the country, and we need to be more selective. We certainly need to be more individualized about how we use that. I think Aaron's point, though, is the one that I agree with the most, and that is it's not so much the population that you identify for detention, it's the process that you put in place to determine whether or not that detention is going to happen. If I am able to if I have that hearing and I can show that I'm not a danger to a particular individual or not a danger to the public, if it's on the government to prove that point, you know, while due process protections are being had, then I think you have a good system going in. So I'm less concerned about who hits a net when it comes to detention, and more so that we have something in place to make sure that all those people are treated fairly.
Yeah, and I mean, one of the issues that's come up, obviously, is what occurred in North Carolina, a terrible murder on the transit system. And obviously, there were a lot of factors about that. I mean, many people think the perpetrator should have been in a mental health institution, given his background. But you know, it was obviously a horrific murder, and it led to the state adopting legislation that gets rid of release on someone's own recognizance, basically, and now everyone will have to pay. And then secondly, it sets up presumptive detention for certain offenses, which is really contrary to what Chief Justice Rehnquist wrote in the Salerno decision, saying that there's a presumption of release. And so I'd be interested in what, if y'all don't think that legislation was the right approach, what would you recommend? And I'll also note the legislation didn't provide any money for pretrial supervision or address the mental health aspect that I just referenced.
But I would like to take that first.
Sure.
So I read all about the case, looking at the real like skeleton, the bare bones of what is the underlying factor. So in New Jersey, we are having the same issues. Post-COVID, a lot of the mental health facilities have closed, and we run across this problem all the time where someone who clearly has mental health issues commits a crime, and should they be detained or should they not, and where should they go, and are the facilities available? I think this particular case is absolutely an outlier, and it was a knee-jerk reaction by the state because of the gravity and the horrific nature of the crime. And I think that they're probably going to go too far with what they're doing. That's going to then impose unfair restrictions on a lot of people that don't necessarily fit into that same box. But looking at that specific case, that gentleman needed help, not a jail cell, right? And by him being released and committing this crime, it is now going to create a whole category of people who are going to be detained in county jails because there's not going to be the beds and facilities to treat them appropriately. So I really think that case is an outlier, and it's going to cause a knee-jerk reaction, and it's going to cause people that have mental health issues to be detained in county jail facilities because the mental health facilities are not available. And I think that's going to be the hard part, and you're going to watch it play out because I'm seeing it here in New Jersey every day. Thank you.
Does anyone else want to address that? I know that there's a debate about, whether people should be able to be compelled into treatment, whether it's for an overdose or somebody who is having a mental health episode. And I don't know if anyone wants to address that particular question. My sense is there are people who need treatment that don't know that they need it in certain scenarios.
Yeah, there's an interesting conversation going on in the pretrial field just about that. Whether services and support are the things that you need to concentrate on rather than conditions of supervision. And if you do that, are these voluntary? Are these simply things that you're offering a person pre-trial that they can take or leave? Or do you have that population where that need, that substance abuse need, that mental health need now becomes a risk and you have to deal with it? And I think that when you do that, when you see a risk that is not something that you solve with the reporting condition, not something you solve with a bracelet, you've got to put those resources in place to make it work. I agree with the DA that these are a very limited population of people, but they certainly exist in pretrial populations, and they certainly are the most problematic people that we have to work with.
Yeah, and I'd just add on in conversations with mental health advocates and mental health experts, I think the same logic that we just laid out when we're talking about assessments for restrictive conditions of release apply here. If someone is going to be compelled into treatment, we want to make sure that there is due process there. I think that's something that I've heard has not existed in a lot of cases, at least in New York when we were doing work on the bail law there. So making sure, again, that there are opportunities to revisit, that there is a standard that needs to be met, that is automatically compelled, right? Every, X amount of time, they have to revisit whether that standard is being met. And to DA Reynolds' points, our policies need to be based on fairness and facts, and not on fear that comes from a rare but very serious tragedy, obviously, because we end up with laws that harm the many, like Spurgeon said, right? There's a real damage and a real harm that comes from unnecessarily incarcerating people and worsening the root causes of crime.
Yeah. And adding to that is, in a lot of instances, my pretrial case is going to end a lot sooner than my treatment placement might. And if that placement is based on me being on supervision rather than a choice I made, well, if my case is gone, I'm gone. And as we've learned from research, interrupted treatment periods are just as bad sometimes as failed periods. So we really have to be mindful of that as well. If we're looking at treatment, perhaps we're not looking at traditional case processing any longer.
Khalil, should I send it back to you? Yeah, I mean, of course, if somebody sends to probation, they could continue in the same treatment program theoretically, but you're absolutely right. If that pretrial services is the end of the line, the treatment may not end when it may end prematurely relative to what the need is. Khalil, back to you.
Yeah, thank you, Mark. We have a ton of questions coming into the Q&A. So I do want to ask one quote unquote brief question before we get to as many of the questions from the audience as we can, because this is a lingering concern. And this is one of the reasons that we decided to host this webinar, particularly on this issue. And so I asked the panelists if we can keep our answers as brief as possible so we can get to as many questions as possible. What would the consequences be if federal funding, according to President Trump, is pulled from jurisdictions who do not roll back their bail reform policies?
I'll jump in because I actually had a meeting with all other county prosecutors in New Jersey this morning, and this was one of our agenda items. Two things, grant funding that would be pulled would affect our services for victims. Our victim witness advocates, VOCA and VAWA grants are 100% funded through the federal government, through the state attorney general's office to us. If that grant funding was cut, we'd have no victim services.
Aaron?
That's exactly right. These are the grants that are being targeted are grants that go to making communities safe. I also want to emphasize that some of these grants have already been slashed alongside Medicaid, which is a proven public safety intervention. But these are funds that go to the very things that make communities safe, violence interruption programs, et cetera. But I also want to be clear that these funding threats are not about public safety. They're about power grabs and politics, because as we've spent the last 47 minutes discussing, bail reform is working and it's not harming public safety. Crime is going down in the very places that are being targeted, which is demonstrating that community-based safety and local decision-making is working. And so if this were really about safety, the federal government would be supporting these results and not threatening to punish them. And so I think that in addition to harming public safety programs and interventions, there's a real threat to trust in local decision-making around public safety interventions and damage to democracy.
Yeah.
Spurgeon, same question to you.
I'm a little less concerned about the executive orders as I am the two pieces of legislation that are moving their way through Congress, because they would, one, codify the executive orders in the law, and secondly, expand past just justice-based grants when it comes to taking monies away from states and localities. As we know, that people who are involved in the justice system really are lower income people, and that's our group. I don't see the point of deconstructing the lives of those people any further, just to, as Aaron said, just to prove that you can take something away from people. Yeah, it would have a devastating effect if those laws were passed, I think.
Thank you all. We're going to jump into the questions. As I said, we have a lot of questions coming in, so we'll try to combine some, synthesize some, and make them as straightforward as possible. So first question, and this is open to anyone. Can the panel comment on the specific impact of bail reforms on women? Have they resulted in a significant reduction of women detained pretrial?
Well, I'll mention, I know there's data showing women on average have less access to financial resources. So they're on average less likely to be able to post bail. And of course, I mean, one of the things that occurred to me earlier is when we were talking about making everybody pay, which is, getting rid of ROR. Obviously, if you have a gang leader, right, that guy's got a bunch of money to get himself out of jail, but a woman or anyone who's kind of a mule and just, at the bottom end of the thing often doesn't. So you can end up with this, the result contrary to what a policy, what our intention might be, is to keep the really bad person in jail and keep and let out the person that is less of a risk. But did anyone want to comment specifically on the women question?
I'll take that from another angle, and not so much women who are incarcerated who can't afford to pay, but usually if a person's incarcerated and made to pay a bail, they don't pay the bail. Families do.
Mm.
And in most communities, those families are headed by women, the wives, the mothers, the grandmothers, the girlfriends. There's at least one study I saw that found that women are the main contributors when it comes to paying bail bonds. So the more you rely on bail, not just for people going into the system, but people with loved ones in the system, you are affecting women that way. So the less reliance on financial bail also has that effect for people who have to pay those bills, not so much those that have to pay to get out too.
Yeah.
We,
So thank you
we
so
had a
much.
really good question come in on the effect of, on the pretrial system, what differences there are from rural versus urban areas. And I think that, of course, access to treatment and counsel come to mind, but would anyone be able to address that, how the issue differs?
Sure, I can jump in on that. So my county, Atlantic County, has urban areas like Atlantic City with 28 million visitors. And then we have rural areas out in excuse me, in the western part of the county. We have blueberry farms and migrant farmer populations. The services that can be offered to Atlantic City are much different because access to all the healthcare and all the professionals and probation and internet service is great in Atlantic City. Out in the western part of the county with the farms and the migrant farm workers and lack of access to facilities, healthcare, mental health, and addiction services and internet service does not exist out there. The challenges are great on the west and much better in the urban areas. So, and that's right in my county. We have 300,000 residents, 28 million visitors, and those who are in the urban areas have much better access than the ones that are in the rural areas.
Yeah, I tend to agree. I think the risk factors you see in rural and urban areas are the same. Certainly, the support services, the needs that we see are the same. The differences of the amount of resources we're able to put towards those issues. And in urban areas, there's just more to it than in rural areas. Um, you said internet, and I never thought of that before. Yeah, I can't do all these great and wonderful things like virtual court appearances and things that we've learned through COVID if I can't get a web connection. So that's an interesting one.
And I would say that's part of what makes statewide reforms very successful in the process when it is organized statewide, because I think that what DA Reynolds raised stands state to state. So it's really important to organize and connect with practitioners, grassroots communities, impacted people across the state so that you're understanding what the infrastructure looks like in rural, urban, and suburban areas. And then I think like Illinois has done and continues to do, and like was done in New York and other places, passing legislation is just the beginning, right? Like that's actually just the first step in the process. You have to go advocate for funding year after year to implement with a real heavy focus outside of the metropolitan city centers, because most often there's a lot of infrastructure in those urban areas and in those cities, which doesn't mean you leave them alone, right? But you really do want to put a focus on rural areas to build up that infrastructure for implementing reform.
Thanks, Erin. And to that point, Don dropped a link in the chat that looked at the differential impact of bail reform in rural Illinois. Third question to the group, how do we better get the data and research which clearly show negative impact on crime into the national conversation on bail?
So I'd like to jump in on this because it's a challenge I have every day. We have a watchdog reporter who has an independent blog, independent website, and does some local streaming, who left our major paper, Atlantic City Press. She watches all the detention hearings. She gives great coverage. I cannot get anyone at the next level, like Philadelphia, to actually cover all of the great work that's being done by utilizing bail reform as a public safety tool. So I'm getting local coverage. So the local, people in the county and in the general area know but it's very difficult to get that message at like the Philadelphia media market, because it's the 30-second clickbait, right? They get more hits if something tragic happens. They're not getting a lot of hits when they say, oh, you know, crime's way down because bail reform's great, right? So this local reporter literally watches our detention hearings and gives us great coverage. It's a struggle. It's a struggle to get you know, national media markets to pick it up. And how do we do it? You know, it's clickbait. They're making money on things that, you know, sell the clicks, and this isn't necessarily something that sells the clicks for them. And it's a challenge. It's a challenge.
I think another issue here is a lot of people involved in the justice system aren't in a position where they can go and talk about this. There are policies in place sometimes that limit what a court personnel can do, what pretrial agency personnel can do. So in that sense, we're not going to be our best messengers when it comes to this. But I think you're right. It's finding those people, getting the information to them, and helping them phrase what the message ought to be is really the best way to go. It is difficult because, hey, this works. It's not a good news story. It never has been. But yeah, finding those people, finding those media outlets, being able to speak when you can, I think is the strategies we have to start looking at.
And to the point of messengers, I think having everyday people having conversations with everyday people is really powerful. Even being an advocate and not having limitations on who I can speak to when. I work for the Bail Project, so people are going to assume that the Bail Project is going to say what you'd think the Bail Project is going to say. Think taking a report, and when you go to church, when you go to a community meeting, when you're picking up your kid at school, having a conversation actually has a huge impact. And trusted messengers may be talking to a friend, and that inoculates people from those hysterical, fear-mongering articles.
The one other thing I want to add, which I have done, and I've been criticized for doing it, is I've taken some public positions and written op-eds on the use of bail reform as a public safety tool, and tied in expungements as well, and showed that the benefit of expungements of moving people on with their lives to become contributing members of society, just giving straight facts, you know, and I've used that tool in this position. Again, I get state level coverage on that. It's not getting really outside the borders of New Jersey though, but that's a place to give our message and to say what the actual facts are. And the one thing that's been clear is that when people are given the facts, they still may choose to not pay attention to them, which is also interesting. But, you know, I think from a perspective of being in a position of leadership, you have to use every tool at your disposal to get out the message and rely on facts. Thank you.
Thank you so much, Prosecutor Reynolds and Aaron. And Spurgeon, we're gonna take the last minute and a half to do some quick closing remarks, and then Mark and I will just close out. So whoever wants to go first. Aaron, how about you?
Yeah, I was just trying to get myself off mute. I think what's really exciting about the moment that we're in right now in bail reform, and I've been at this for a while, is that it's no longer a fringe idea and it's no longer a theory, right? It's a tested model, it's a working model. And so the recommendation, I think, for moving forward is really we just have to have the moral resolve to protect what's working. It's really exciting to be on this panel where we're approaching this from many different angles, many different areas of expertise. So we just have to protect what's working and keep expanding it.
Thank you. Prosecutor Reynolds?
So I couldn't agree more. I think we have to focus on what is actually working and then focus our efforts in the future on how do we refine those things and better the system that's being built. New Jersey has had the political will and the acumen and the support from both sides of the aisle to move this forward. It started with Governor Christie. It has evolved under Governor Murphy. We're getting ready to have a new governor. We just hope that we're able to continue working on it going forward. Thank you. Appreciate the opportunity to be here.
Thank you, Prosecutor Reynolds. And Spurgeon?
And I want to go back to something Mark mentioned earlier, and that is we've been in the business of bail reform since the 1960s. This has been a 60-year project. It hasn't just happened recently. And we've had these periods of being up and being down, of people being on our side and then running away from us. I think we have to start making a more conscious effort to learn from these periods of time, to be able to document what has been successful before, what we can keep moving forward. But yeah, we have a lot to learn from past efforts. And I think we need to always look back at the people that created this movement and what their contributions were and how they've been able to help and how we can make those things the things that we move forward as well.
Well, thank you. On that note, thank you everyone for your time. Everyone that joined us today, thank you for your time. Thank you for your questions. We tried to get through as many of them as we can. And as usual, an hour is never enough time for complex issues like this. I want to thank obviously our speakers and presenter, Don, Prosecutor Reynolds, Aaron, Spurgeon. Thank you so much for your time and lending your expertise and your perspective on these issues. And of course, I want to thank the CCJ team, of course, my colleague and co-leader of the Center and Justice Initiative, Mark Levin. Thank you to Olivia McLarnon for literally keeping the trains running on time, keeping us all in line, make sure we get here and make this easy for us. Thank you to Rachel, Brian, Eric, Andrew, and the entire CCJ team, as usual, for making this easy for myself and Mark. Thank you, everyone. Have a great day.
Thank you.